I'm going to read through this case. It dates back to 1994 and it involves the Belfield Comprehensive High School, which is now the Belfield High School. Now, before I read, let me just state that I myself am not an attorney at law, but I know it's important that we as members of the public read and learn about the laws of Jamaica, and some of these cases clarify some of the things that we need to know. Now, I want you to look at the description of the video for the direct link to this document at the Supreme Court Library, and also another video which I myself made up, laws that those of you who watch or listen to this video should follow. All right? Now, let's start reading. In the Supreme Court of Judicature of Jamaica, in full court, you have the justices being named here. In the matter of an application by Carmen Williams to apply for orders of certiorari and prohibition, and in the matter of the purported dismissal of the applicant as executive secretary at the Belfield Comprehensive High School. So, Carmen Williams was dismissed from her job as executive secretary and brought this case against the school. Now, the attorney is Mr. Donnell Gitton for the applicant. That's Miss Williams. Mr. Laxton Robinson, Assistant Attorney General, instructed by the Director of State Proceedings for the respondent. The respondent is the Belfield Comprehensive High School. All right. It was heard in November 1 and 2, 1995. This is an application and motion for the following orders. A. Order of certiorari to quash a decision made by Dr. Arma Folks, principal of the Belfield Comprehensive High School, as stated in letters dated the 30th of August 30, 1994, that having abandoned her post, she should stay away from the school. And an order of prohibition restraining the board of the school and any subcommittee or agent or servant thereof from pursuing any charges or conducting any hearing relating to the purported dismissal of the applicant. Background: the applicant, Ms. Williams, commenced employment with the government of Jamaica in November 1966 at the St. Elizabeth Technical High School as a clerical assistant and continued as a stenotypist until December 1976 when she resigned. So she spent 10 years at the St. Elizabeth Technical High School. In January 1977, she was employed as executive secretary to the principal, Belfield Comprehensive High School. Her appointment was approved by the Ministry of Education in a letter dated June 16, 1986, directed to the chairman of the Belfield Secondary School, Manchester, and copied to the applicant. The appointment was effective on January 1, 1978. Okay. So even though this is such an old case, I decided to read it because it involved a high school, and persons working at a high school and are dismissed from their job might find some of the information here useful. On the 13th of June 1994, the applicant made a written application for 35 days vacation leave commencing on the 11th of July 1994 and concluding on the 29th of August 1994. Prior to the application, the principal of the school had discussions with the applicant and others and informed them that they were not entitled to 35 days annual vacation leave but 21 days instead. Okay. So it was only 21 days, not 35 days. The discussions were prompted by the Ministry of Education. Okay. So it seemed as if Miss Williams applied for 35 days vacation leave and it was sent to the ministry. But then the ministry replied and said no, only 21 days would be allowed. Now, at the time of the discussion, the applicant expressed disagreement in respect of her leave entitlement. So Miss Williams disagreed with the 21 days. She wanted 35 days. On the 23rd of June 1994, the principal refused the application for leave and accordingly informed the applicant both orally and in writing. The applicant returned the application for leave, which was endorsed by the principal, indicating her refusal. It is disputed by the applicant that she told the principal that she and her business planned would be going away. She had her business planned and would be going away. Okay. So remember, if you apply for leave, you should have access to the documents such as staff orders that show how much leave you can get. Right? But even then, remember that, for example, a principal of a school might not grant or might not agree with the leave, or the Ministry of Education in this case might not approve of the leave, even though you're entitled to it. All right. On the 24th of August 1994, the chairman of the board convened a meeting comprising himself, the principal, the bursar, and the applicant. At the meeting, the applicant, Miss Williams, admitted to the chairman that she knew the leave was not approved, but that she went on leave because she disagreed with the position taken by the principal on the matter. And moreover, she was not well and the doctor had advised her to rest. But if that was the case, what she should do is take in a sick leave from the doctor. That's what she should have done. On the 30th of August 1994, when the applicant returned to work, the impugned letters were handed to her by the principal. Representations were made on behalf of the applicant by her attorney to the school board, and charges were preferred against the applicant. That's against Miss Williams. A meeting was convened by the school board and at that meeting the principal of the school was present. Right, grounds for the application. The grounds upon which the application is sought are that she said decisions purport to dismiss the applicant. The said decisions purport to dismiss the applicant, and accordingly they are ultravirus the statutory regulation and in breach of the principle of natural justice. So this is saying it goes against the statutory regulations. In respect of prohibition, the scheduled hearing into the charges against the applicant is repugnant to the public service regulation, and there is real likelihood of bias. Submissions. Mr. Gitton, on behalf of the applicant, submitted that the applicant was dismissed. That Ms. Williams was dismissed without a hearing by letters dated the 30th of August 1994, since she was not allowed to resume her position at the school on that date. So you see, the school board really should have had a meeting with her and had a hearing. They should not have just sent her a letter like that. There should be a hearing. Should conduct a hearing first, right, to hear her side of the story. Now further, the applicant, having been appointed by the Ministry of Education, was a member of the public service and was governed by the public service regulations instead of the education regulation. Okay, so she was not a teacher in this case. So it's not the education regulations that would govern her. It would be the public service regulation. Even though she was appointed by the Ministry of Education. So that's what her lawyer is saying. Because the applicant was appointed in 1978 prior to the 1980 Education Act and regulations, the applicant should have the benefit of the earlier regulation pertaining to suspension. The latter regulation he submits does not address suspension, while the earlier regulation does. It is an accepted principle of statutory interpretation that a right existing at common law or under statute cannot be abrogated by a letter statute unless the abrogation was expressed or let me read that part again. It is an accepted principle of statutory interpretation that a right existing at the common law or under statute cannot be abrogated by a letter latter statute unless the abrogation was expressed or by necessary implication, by the way these lawyers write, especially in older days. But anyway, we're going to continue reading this document at the point where it said he finally submitted.